All right, everybody. Welcome to session 2, and we have a great panel today. We are going to talk about non-market economies, and there'll be a brief discussion of a pending panel report. We thought we might have it by today, but we do not. But we're going to talk a little bit about what may or may not what the issues were and maybe where that's going. We're going to talk about the situation created by, in the context of non-market economies, market distortions, and then we're going to talk about, various of the panelists are going to talk about reforms related to non-market economy issues and sort of the approach of various countries here. So briefly, I will introduce our panelists. I'm not going to do bios because you have everybody's bio in the little packet that you got. I'm Stacy Ettinger, K&L Gates, and an adjunct professor at Georgetown. And to my left is Shirzad Shadahovich. Okay, I'm working on that. Eugene Kim McNamara, thank you so much for coming. And we have Philippe Debar and James Nadampara, and then Tim Brightbill. And so this is, in fact, the order of our presentation for the moment. So what we're going to do is each of the speakers is going to give about a 5-minute talk on, they have sort of various issues to talk about, so we get a broad overview of this issue. And then we're going to do a deep dive on some of these issues, and the panel's going to have a discussion. I'm going to tee up some questions, and then we'll have time after that for questions from the audience. So again, thank you for coming. I'm gonna turn it over to Shirzad and take it away.
Okay. Good afternoon, everyone. So I think since we're talking about non-market economies and market distortions in the context of a trade remedy context, I thought that it would be a good start if starting with the outline of how the WTO deals with those issues. And the very first point that comes up to my mind is the definition of actually market economy and non-market economy. And to my best knowledge, the WTO agreements do not provide that kind of definition, but there are some indications written into WTO rules that may show whether this or that country could be deemed to be a market economy or non-market economy. So in the context of anti-dumping context, at least there is Article 6.1 at Article 6.1 of the GATT that gives members kind of right to deal with non-market economies, especially non-market economies for strictly regulated countries that have a substantially complete monopoly of trade, and where the prices in domestic market are essentially regulated by the state. So when it comes to a general outline of how a trade remedy could work to deal with non-market economy and market distortions, then here we have basically two approaches. The first one is the Subsidies and Countervailing Measures Agreement that provides a definition of subsidy so as to restrict certain government interventions that work to support their local industries. And at the same time, that agreement gives a right to challenge those subsidies at the WTO level or to countervail at the domestic level. And in the case of the anti-dumping agreement, then this agreement, unlike the subsidy, deals basically with the trade distortive effects of government interventions. That means the subsidy agreement deals with the root of the government interventions, and anti-dumping deals not with the root itself, but with those market distortive effects. And the problem with the trade remedy rules of the WTO these days isn't that they are considered as being a bit outdated, especially when it comes to how the anti-dumping rules can address non-market economies, because those rules under Article 6.1 of the GATT were created in the 1950s to address certain distortions in the countries like Czechoslovakia or Hungary. But now with the countries like China and Vietnam and Tajikistan and some other countries in the WTO that have certain accession commitments dealing with non-market economies, and whose those provisions have elapsed, except Tajikistan. Now we have a kind of new rising issues regarding with non-market economies. This is why recently many countries like the EU, the United States, Australia, and others, they try to use the existing regime for particular market situations in replacing state-distorted cost with third countries or other international benchmarks that are believed to be non-distorted by states. And my final point would be in saying that the new issues, the emerging issues with market economies that are believed to be not adequately addressed by the WTO regime could be additionally the state-owned enterprise issues, and also recently the overcapacity issue, that overcapacity in steel and other industries where that phenomenon is linked to inadequate government interventions. Yeah. Thank you.
Okay, I think this is on. Good afternoon. So we have a lot of cases, a lot of WTO disputes in the pipeline involving systemic issues with trade remedies issues. And when I say trade remedies, I'm considering this broadly to not just traditional anti-dumping and countervailing issues, but really just the gamut of trade remedies and the trade actions that countries, especially the United States, has taken in order to remedy alleged market distortions, such as the Section 232 and the 301 measures. So, in the limited time that we have, or that I have, I just wanted to summarize some of these cases and just set the groundwork for discussions with the panel as well as the audience. So probably the main case that's relevant to our discussion with regard to the treatment of NME countries is the Chinaennemy case, which is the EU Price-Comparison Methodology case. I believe the confidential interim report came out in April, and the final panel report was supposed to come out the first half of this year. I'm not sure what the schedule is at this point. But as many of you know, this dispute stems from China's accession protocol, and in particular Article 15, which sets a 15-year time limit or a sunset clause that ended as of December 11th, 2016. And the main issue in this case really is what happened on December 11th, 2016, what actually ended. And so the main questions relating to that being really whether members are permitted to continue treating China as a non-market economy, or if the December 11th deadline set a graduation date for China, or whether members can, and relatedly but separately, whether members can continue to apply a non-market economy and NME methodology in anti-dumping proceedings that are not based on a strict price comparison method, such as the surrogate country method that the United States uses. And so I think that we'll see a lot of these interpretive issues played out, but Article 15 is not a model of clarity. It's really not clear exactly what the individual provisions and the subparagraphs intend to say. So, very reasonable minds have differed significantly on what this could mean, and it has been very divisive and contentious to some degree. So I think that, some of the interesting issues that come out of this dispute is, first of all, as Shirzad mentioned, there isn't really a defined definition of what a market economy is or what a non-market economy is. So how are we going to address those issues? Especially when, for the most part, it's really not a binary decision of is a economy completely market-oriented or is it completely non-market-oriented. There's going to be gradations in both categories. And China is obviously a very different country than it was in 2001, but maybe not to the degree that we expected it to be at the time that the accession protocol was drafted. So what kind of flexibilities does Article 15 provide in accounting for the fact that maybe the assumption back then might have been that there would not be a need for a non-market economy methodology in 15 years, but if the conclusion is that China has not met the standards that we expected it to meet, then how do we address that? And if the December 11th deadline was really a hard deadline that was negotiated, and we are bound to that, then do the provisions of the WTO rules, the anti-dumping agreement or the GATT rules, provide for some flexibility in how to deal with markets that we consider to be non-market economies, even if we are not allowed to use an NME methodology. So, I'd be very interested to hear, everyone's thoughts on that, but I just wanted to also briefly touch upon some of the other trade remedy measures, and namely the Section 232 and the 301 measures that are also before the WTO. As you know, the United States imposed Section 232 tariffs against steel and aluminum imports into the United States under the basis of national security. 9 countries have challenged the U.S. on these measures under various provisions under the GATT as well as the Safeguard Agreement. Recently, Mexico and Canada have reached a mutually agreed solution with the United States and have withdrawn these cases, so 7 remain. And separately, countries have also imposed retaliatory tariffs on the United States, and the U.S. has also challenged those retaliatory tariffs. The U.S. had challenged 6 countries, again, Canada and Mexico have reached a mutually agreed solution, so those have been withdrawn. And then also the trade war cases, or the Section 301 cases. As the United States has, through its 301 investigation on China, the U.S. has taken primarily 2 measures. It's initiated a dispute against China at the WTO, and it separately imposed certain tariffs under the 301 authority. So the U.S. has brought a case against China regarding IP issues, and China has also brought a case against the United States with respect to the tariffs that were imposed as part of the 301 measures, which have also continued to be updated as additional tariffs and additional measures come into place. So some of the issues that come out of these really are, what we've what a lot I think is a really hot issue right now. What are the bounds of the security exceptions under Article 21? How far can we expand the discretion that's granted to members to determine for themselves what a security interest is? And also whether the 232 measures can be considered a safeguard and examined as such when the United States hasn't brought the measures as a safeguard measure. And also how to address retaliation generally in the WTO, I think, is going to be an issue, particularly as members have started to retaliate unilaterally for whatever reason, and under the WTO regime and the dispute settlement regime, how the WTO really is going to address that if this becomes a more common practice among countries. So I'm interested to hear everyone's views on that. Thank you very much.
Thank you. Let's now look maybe at how the European Union dealt with these issues, because the European Union is one of the main countries that actually adopted or adapted its anti-dumping regulations following the expiry of Section 15 of the Protocol of Accession. So how did they do that? And I will concentrate on 2 main changes that were made. The first one was to introduce a new methodology for the determination of normal value. For those innocents amongst you who are not aware of the terms of anti-dumping, dumping is actually when your export price falls below the price on your domestic market, or a substitute for that, which we call normal value. So the substitute is normally in Europe the so-called constructed price, so the price at which your product would have been sold on the domestic market if you had constructed the price on the basis of your costs in your records. The first one was the new methodology, which is different from domestic price and constructed normal value. And the second change was a change to the so-called lesser duty rule. The lesser duty rule is a rule which implements basically Article 9.1 of the anti-dumping agreement, which says that you can impose a duty which is, it's desirable to impose a duty which is below the margin of dumping, where that duty would be adequate to remove the injury. So what did the European Union do? As I said, this was mostly motivated by the fact that, as we heard on the 11th of December 2016, the Section 15, or parts thereof, of the Protocol of Accession of China expired. And the European Union had a very practical problem, namely that in its articles on the determination of normal value in the basic anti-dumping regulation, they expressly referred to China as a country for which a non-market economy methodology needed to be applied. For the audience here, it will not be a surprise to say that this is quite inconvenient to have China singled out in your legislation. Under WTO law, obviously, you would have a difficulty there. So what was, and then the other change, the lesser duty rule, was mostly born out of the frustration by the European industry to see that they managed to get 150, 160% dumping margins and then duties of 12, 13%, because the Commission found that it was sufficient to impose such a duty. So what was done? They developed, as I said, a new methodology for both approaches. And the objectives of the new methodology was first that it should be prima facie country neutral, that China was no longer singled out on its face. It should, however, lead to the same results and the same level of anti-dumping duties against China as under the previous methodology. And it should not increase the burden of proof on the complainants, on the European industry. In the past, it was statutorily defined that China was a non-market economy. So the new system should not increase the burden of proof, and it should not endanger the existing measures. So these should be grandfathered. Now, for the lesser duty rule, the European industry wanted to have the same level of duties as they saw in the US, which didn't have a lesser duty rule, because otherwise they said this leads to diversion. How did the EU address that? Well, the first idea was no longer to talk about non-market economies, but about distorted economies, which is basically a non-market economy under a different name. But officially the test now applies to all WTO members and not only to the NMEs previously listed. You are a distorted economy if in your economy you have significant distortions. And what are significant distortions? The new legislation or regulation says distortions, significant distortions are distortions which occur when reported prices or costs, so reported prices or costs, are not the result of free market forces, because they are affected by substantial government intervention. Which brings us then to what is the notion of substantial government intervention. And we have a number, an illustrative list, which is not exhaustive. And what do we find on that? A large presence of state-owned enterprises, state presence in private firms, public policies in favor of domestic suppliers, subsidies, dual pricing, export duties, and financing by public banks. In case the Commission finds such distortions, it may, there is a level of discretion left, it may construct normal value on the basis of, and here we come, the costs and prices in an appropriate representative third country, which is precisely in the past under the former methodology, where with China we rejected prices and costs, and we would look at an analog country, which is a market economy. So here this has become representative, representative prices and costs in an appropriate third country, or international prices for in the London Metal Exchange, or undistorted costs in the exporting country. How did they deal with the burden of proof? Basically, the Commission said, for countries that we know that such distortions exist, we will make a report detailing the existence of such distortions, and complainants may, in their petition, in their complaint, simply refer to this report as a basis for the application of this new methodology. On the day the new measures entered into force, the European Union published a country report which surprisingly covered China. There was no other report, and there has not been any other report published until now, although rumor has it that one covering Russia is in the works, and so we will probably get one in the coming months. The other side, if you are a Chinese exporter and you want to prove that your prices and costs are not distorted, then the burden of proof is on you. And you must positively establish that your prices and costs are not distorted on the basis of accurate and appropriate evidence. No exporter has tried even to do this until now. The grandfathering, existing measures on the basis of the old non-market economy methodology have been grandfathered, because the new methodology will only apply during the first expiry review of the measures after the entry into the force of the measures. Now, what does that mean? If you have duties determined on the basis of the non-market economy and there is a sunset review, they will apply the new methodology. But if under the new methodology the Commission finds the existing of dumping, they will continue into force, they will keep into force, they maintain in force the existing measures which were based on the old methodology. So this is a way actually whereby these old duties, which were determined on China under the new market economy, under the non-market economy system, can actually be prolonged for up to 10 years. Because you will have to apply, if you're an exporter and you see that the new methodology leads to a lower duty, you will have to apply for an interim review. But the Commission has already stated that the fact that there is a new methodology is not a sufficient reason to justify the initiation of an interim review. So there will have to be additional change of circumstances which will have to be decided. So lesser duty rule, very simple. Lesser duty rule is also based, surprisingly in fact, on the existence of raw material distortions. So if in an exporting country the Commission determines that the raw materials, including energy, is distorted by government intervention, then they can decide not to apply the lesser duty rule. This raw material distortion must affect a raw material or an input which accounts for at least 17% of the cost of production of the exported product. So until now, the only case in which that has been used is in a recent case on fertilizers, UAN from Russia, whereby that the lesser duty rule was not applied because in the production of the fertilizers, the gas, which is one of the main components in the production process, main inputs, was distorted by government intervention. And I conclude with a question, really. We have seen that for the new methodology on normal value, distortions may lead to the rejection of the domestic prices, domestic costs, and the application of this new methodology. However, it seems, from what has the Commission's practice until now, that the existence of distortions leading to the non-application of the lesser duty rule do not necessarily lead to the application of the new methodology for normal value. So you can have, for normal value, the traditional methodology as was applied to Russia, while at the other hand, at the time of the lesser duty rule, the Commission finds the existence of significant distortions. Why doesn't the Commission apply then also for the normal value, the new methodology? Question.
Thank you, Stacey, and thank you, Juice, for this opportunity. In fact, reams of articles have been written on this topic about Section 15 of China's Protocol of Accession and Article 6.1 of the GATT and the Ad Note. So I'm not going to talk about any of these issues. I'm going to specifically talk about India. So when you look at the context of India is actually perhaps the largest initiator of anti-dumping actions, but Indian actions do not have that kind of an impact on Chinese products. To put the facts in perspective, India has initiated around 192 actions until 2018, out of around 800 actions. So it is a substantial number of actions, and I'm sure that no other country has initiated more actions against China. So when we think about the Indian anti-dumping practice, I think I should say that India has been hiding and trying to find out what other countries are actually doing with China. So interestingly, in the context of India, India had a kind of an enemy list, an enemy category of countries in 2001. So when new WTO members acceded to new countries acceded to the WTO, then some of these countries were taken outside the list. So by 2002, this list was basically scrapped. But there was a provision in the Customs Tariff Act, which is the underlying legislation in India dealing with anti-dumping investigation. There was a provision to deal with non-market economies. And in the case of a non-market economy, if the price and cost in that particular country has been affected by virtue of a state intervention, then three options were given to the investigating authority. The first option was to look at a surrogate country. The second was to go for the constructed normal value methodology. And the third option was to use any other reasonable method. So that is very interesting, any other reasonable method. And there has been a trade notice as well, but saying that in the case of a non-market economy, they will have to fill up a questionnaire. So something very interesting happened until, after December 12, 2016, India has removed the non-market economic questionnaire. But still India believes that, I think according to my understanding, the anti-dumping authority in India believes that there is still a burden on the Chinese exporter to say that the prices in China are not actually distorted by virtue of the government intervention. So there is still a kind of a rebuttable presumption on the Chinese exporter, but that presumption is not going to be rebutted by filling up a particular questionnaire. So that is actually a major change that happened after December 12, 2016. So now let me again talk about the other interesting fact. So in the context of India, I mentioned around 192 actions. So among the 192 actions, it is also fascinating that most of the Chinese exporters did not cooperate with the investigation, and therefore the authority had actually used facts available. So if you look at most of the cases, there was no participation at all, and what the authority did in all these cases was to look at the international prices. So if it is a chemical product coming from China, then the Indian authority used to look at the FOB price in Hong Kong, and then they had a conversion cost and then imposed a very low margin of profit. So the margin of profit has been fairly low. It is also a fairly interesting thing that when India actually computes the lesser duty rule, there is a 22% return on capital employed, which India doesn't really apply in the case of constructed normal value. So the range of profit has been fairly low. And I should say that when compared to other countries, India had actually given market economy treatment to Chinese exporters in a number of cases. So that means the Chinese exporters had an opportunity, if they could really participate in the investigation and demonstrate that the cost and prices are not affected by any government intervention or involvement in the market, they had a reasonable chance of actually using their own normal value. And if I look at the number of cases, in fact, I had come out with the book very recently. So there's a chapter in the book specifically related to India, and the authors of the chapter have looked at all the cases, and in 15 cases, 15 out of 192 cases, at least some of the exporters were actually able to use their own normal value. So which is a good thing. So India didn't have a very close mindset with respect to giving individual market economy treatment to Chinese exporters. Another important thing which I would also say a little bit about the particular market situation, because if you look at the anti-dumping agreement, there are multiple ways in which you can actually deal with this market distortion. Obviously, the category of ordinary course of trade itself is a fairly big category. In addition to below-cost sales, affiliate party sales, non-viable sales, it can also include perhaps certain amount of distorted sales as well. So then secondly, you have got a low volume of sales, and then the third category is particular market situation. India is actually one of the very few countries, I should say, along with Australia, to explore this particular market situation. And that methodology did not really apply against China. It actually applied against Saudi Arabia. And it was a case involving polypropylene, and the input that was used in the production of polypropylene was propane, a feedstock, a petrochemical feedstock. So there, I think the Indian domestic industry alleged that there is a particular market situation, and the dumping authority agreed with that argument, and Saudi Arabia was actually was considered to be a particular market situation. But interestingly, I think that actually led to a kind of a political issue between India and Saudi Arabia, and eventually the duty against Saudi Arabia was lifted. It was only maintained against Oman and Singapore. So that was actually one of the cases. Then again, there is one more case called the carbon black investigation. So in some of these investigations, the Indian authority had actually used particular market situation, but the problem is that definition itself is overly broad. Nobody knows what it is actually. Now, if you look at the American, the Trade Preference Expansion Act, there is a definition of what is actually a PMS, but that is tied to the OCT category as well. So I should say that the jurisprudence in this area is basically expanding, and sorry. And my own feeling is that it will be very, very difficult for a country any anti-dumping investigating authority to use only Article 6.1b, to use the continued non-market economy methodology. Because it is absolutely difficult to find a country that is completely distorted, where all domestic prices are actually fixed by the state. So maybe I think most of the anti-dumping users will have to look at another methodology. Particular market situation could be one of the options, which I think, in my opinion, will be increasingly used against China and maybe other countries. May not be China, because any country, it can actually be used against any country. As if you look at the recent US example, there has been one case on OCTG product from Korea as well. And there have been many such examples in the past. The second is, my own feeling is that the OCT, the ordinary course of trade, that test will be used as a catch-all term in order to cover some of the market distortion examples. So these are some of the anecdotes and facts which I can narrate from the Indian side. And I should also say that reforms are actually being suggested, because everyone is looking at the outcome of this dispute. So once the dispute finally comes out, I think most of the countries will take an approach. I would like to add one more point and then close my statement. So India did not actually do anything with respect to China after December 12, 2016. India's argument was that although the investigation was launched after December 12, 2016, the period of investigation preceded that particular date. So based on that argument, India did not actually change the methodology with respect to China or any country for that matter. So, but I think all the situation will change maybe once the panel report is out. Thank you.
Great, thanks Stacy, and thanks to the Graduate Institute and Georgetown Law for organizing this event. I should start with the standard lawyer disclaimer, which probably applies to everyone here. These are my personal views. They are not those of my law firm, my clients, or the Trump administration, all of whom may violently disagree with what I'm about to say, or maybe not. I thought I would use my time to discuss, similar to what my co-panelists have done, how the United States addresses distortion, first in non-market economies and then in market economies with the particular market situation language. So the United States, in many ways, was the forerunner of the non-market economy methodology. It's been developed for decades. It has not changed recently. And this is probably review for many of you in the room, but just to make sure we're all on the same page, as was pointed out, there's no WTO definition of what is a non-market economy. The US law does have such a definition. There's a 6-factor test under US law for determining, for the Commerce Department in particular, to determine whether a country is a non-market economy. Some of the factors include currency convertibility, labor rights, control of the means of production, openness to foreign investment. There's also a catch-all factor, so it's very flexible. None of those factors are dispositive. And those factors were also developed in the Soviet Union era decades ago. You could question whether those are still the most relevant factors. Then the non-market economy methodology is that the United States takes a 2-part approach. They value the factors of production using the non-market economy factors. So the test was developed with regard to golf carts from Poland. I didn't know that Poland had a golf cart industry, but it did, and that was the first non-market economy case in the United States. So in that situation, you would value the factors of production, the tires, the amount of steel, the amount of labor, the amount of electricity, using the factors from the Polish producers of golf carts. But then you use surrogate values from a comparable market economy to value each of those factors. So that is what's done today. And the Commerce Department will do that using a comparable market economy to value Chinese, to use surrogate values in a Chinese non-market economy case as well. Interestingly, Russia was mentioned. The United States began treating Russia as a market economy in 2001. With respect to China, it is still considered a non-market economy. There was an analysis done in 2006 in the lined paper case by the Commerce Department, and it was updated more recently in an aluminum-related case, a very exhaustive analysis by the Commerce Department of all 6 factors, concluding that while China has progressed in many ways, it still is primarily a non-market economy. Of course, China filed a WTO case against the United States as well. As you all know, that case has not moved forward. Instead, the EU case has moved forward. So China requested consultations with both, but only moved ahead on the EU case. It does raise the question, given this non-market economy methodology, can the United States apply both anti-dumping and countervailing duty law to China? The United States and the WTO have both found yes, as long as there are certain adjustments made for purposes of the calculation of the anti-dumping margins. So that's how the United States addresses distortion in non-market economies. With respect to market economies, it comes back to this particular market situation language. And this language has always been present in the WTO agreements. In particular, Article 2.2 of the anti-dumping agreement, which says that a particular market situation may not permit a proper comparison of sales for purposes of calculating a dumping margin. The United States law and implementing language of the Uruguay round also address situations where this particular market situation could occur. The United States began to focus on this language in recent years as another way of addressing market distortion. In particular, in 2015, Congress passed and the President signed into law legislation that included new language on particular market situations that allows the Commerce Department to depart from foreign producers' home market production costs in calculating dumping margins. So if a particular market situation exists, then the home market sales can be considered outside the ordinary course of trade, as was mentioned. And if constructed value is used to calculate dumping, Commerce can disregard the value of inputs used to calculate constructed value if that particular market exists in a country where the goods are produced. And for example, it has been stated by the Commerce Department that where a particular market situation affects the cost of production for the foreign-like product, such as through distortions in the cost of inputs, it is reasonable to conclude that that may prevent a proper comparison with the export price or with constructed value. So this is not an NME methodology. Its early primary application in the United States so far has been in steel and steel products cases, particularly pipe and tube cases, but some others as well. And particular market situations have been alleged, for example, in Turkey and in Korea. And so what causes the particular market situation? The Commerce Department has gone out of its way to say there are a variety of factors that together cause a particular market situation. And it includes things like steel overcapacity, subsidies that benefit foreign producers, government intervention, for example, in electricity markets, perhaps large shipments of raw materials from countries like China and Russia, and also perhaps strategic alliances between foreign producers of the inputs and the finished products. So all of those things together are what the Commerce Department has used to find that a particular market situation exists. Now, if they find a particular market situation, what do? Right now, it's pretty limited. Commerce will make an adjustment on the dumping side only to the level of subsidies that have been found in a countervailing duty case against those same countries on those products, the input products. So if it's a pipe case and there's a countervailing duty order on hot rolled steel that's made into the pipes, then the adjustment would be whatever that countervailing duty rate is. Now, obviously, that's limited. It only works if there's a countervailing duty case, and it only works if the rate on the input is sufficiently high, more than minimal, to have any impact. So domestic industries have pushed for a different kind of valuation of particular market situation, in particular, an econometric analysis that would attempt to show the impact of global overcapacity of steel and how that affects the input costs in a country like Korea or Turkey or what have you. Commerce Department has not moved ahead on that yet, so that's pending and something to watch in coming months and years. I think, given our time considerations, I'll skip over the discussion that we've already had on how the WTO has looked at particular market situation. And I'll point out there are a lot of other tools that can be used to address distortion. These are the primary ones. I would just say that things like safeguard measures, for example, are not in particular a non-market economy remedy, of course. They're applied to all countries, and they could become increasingly significant given evasion and circumvention of anti-dumping and countervailing duty orders. Similarly, we can talk about Section 232 and 301 in the questions, but those are, again, not really non-market economy or distortion measures per se. They're either national security measures or actions taken to where U.S. commerce is burdened and restricted or where trade violations occurred. So happy to address those as we move to questions. Thank you.
Thank you very much for those presentations. I have a couple questions that I want to tee up for our panelists, and part of it, this one's definitely directed at Philippe and Shirzad as well. I want to go back to the discussion that you had about the EU's introduction of a new methodology, and ask you sort of this distorted economy approach that the EU is applying. What's the legal basis for that under the WTO rules, and have a discussion about that. And maybe Shirzad, you could then comment on, what you think about the EU reforms on significant distortions, and, do they make sense, and do they make sense in the context of sort of WTO rules as well? So, Philippe, I'll turn it over to you.
Thank you. Thank you, Stacey. How much time do I have? No. I think that the methodology on distorted economies or distorted inputs applied by the EU is very difficult to reconcile with WTO, and I don't think even it's possible. Why is that? Because if you know the anti-dumping agreement, there are different steps to determine normal value. As you have, I forget for the moment the state-run centrally planned economies from the add note to Article 6. But if you look at the anti-dumping agreement, you will see that first you have prices. If prices cannot be used for one of the reasons that they are not in the ordinary course of trade, that quantities are insufficient, or there is the existence of a particular market situation, it's fine. You can ignore these prices, but then you have to go to the cost of production, which is defined very precisely in the anti-dumping agreement. So it's not because you have a particular market situation that you can just ignore the costs of the producer. So you will have, even if you find that there is a particular market situation, you will have to look at the costs of the producer. What does the European Union do really is introduce another reason for rejecting this, the domestic prices, saying that the prices and costs are distorted. Costs are distorted. We ignore prices, and we will also ignore the costs. So you jump or you mix up the different stages there. We all know that for the second part, what if we assume that the EU would be able to somehow put its approach under a particular market situation, you would then come to the costs. And we have had a number of WTO disputes which precisely dealt with what costs can be used. Thinking about Argentina and Indonesia biodiesel, the Ukrainian UN case, which clearly point at the purpose of coming to a normal value based on the costs is to reconstruct in a way the price at which the product would be sold on the domestic market. And it's not the construction of what you consider as would have been a reasonable price on that domestic market. So it's not because you consider the price of certain inputs as not reasonable that you can say, oh, we replace them by other costs. No, you have first of all, you have to use the prices as they are reflected in the accounts of the exporting producer. If for one reason or another these cannot be used, and we all know the footnote in the appellate body report of biodiesel, which says you can rely on information from other markets, but information, you cannot just take these costs. You have to take the information relating to prices and costs in other markets and adjust them, adapt them, in order to reflect the situation in the home market and the exporting market. So in that sense, the approach by the EU of saying, if there are distortions, we ignore prices, we ignore prices and cost, is already, in my view, a violation. And the second violation is the way the international prices are then used in order to reconstruct a price which is considered reasonable by the European authorities. There are further violations, obviously burden of proof. You have a reversal of burden of proof. You create a general presumption that China, the costs are distorted. And let me read something that came out the day before yesterday, the 5th of June, in a case involving China, an expiry review under the new methodology. And this really says what is the approach of the European Union. This is the the anti-dumping measures on aluminium foil from China. Significant distortions affecting the domestic prices and costs in the People's Republic of China. How do they start? The very foundation of the Chinese economic system, i.e. the concept of the so-called socialist market economy, is at odds with the notion of free play of market forces. That concept is enshrined in the Chinese constitution and determines the economic governance of the PRC. So this is a very broad brush. So it's not that actually they will look at the individual cost items and whether they are distorted and do that. No, on this basis, the simple fact that you're a Chinese exporter is sufficient to ignore your prices and costs. And you would have then the burden of proof to show as an exporter that this is not the case. We had a similar situation a few years ago in fasteners, whereby that the individual exporter had to prove that they actually operated free of state influence before they could get an individual duty. In that case, the appellate body has clearly ruled that the imposition of the burden of proof on the exporter is incompatible with the anti-dumping agreement. Yet, we have the same approach here. Grandfathering is also, in my view, something which is very difficult to reconcile with the WTO obligations. And these are violations, in my view, which are completely independent from what the WTO panel will do in DS 516. I don't think the analysis will change as a result of that dispute. Thank you.
From my perspective, the EU's new approach regarding the significant distortions, and I do agree with with other scholars and practitioners that would say that they are highly likely to violate certain WTO obligations, certain WTO rules, given the EU biodiesel jurisprudence. But on the other hand, from my perspective, at least economically, this approach does seem to make sense because, first of all, it has this anti-distortion policy in mind. And if we consider trade remedies, especially anti-dumping, countervailing duties context, that they all deal with, with practices that are distorting trade and unfair trade practices. So having that in mind, I don't think that the EU's approach is necessarily unreasonable in economic terms. And also the second point is, since the Article 6 of the GATT already allows a discard of prices from non-market economy, why cannot the same logic apply to the production costs that are distorted exactly in the same way as those prices from non-market economies? And the second point is, in the subsidies agreement, we have well-established jurisprudence saying that if the subsidizing country's market is largely regulated by the government, then when the investigators, they determine the existence of the benefit, they may refer to the external market benchmarks that are believed to be not distorted. Again, the subsidies agreement is part of that trade remedy approach, and bearing these 2 points, we can say that EU's approach in principle makes sense. But on the other hand, we have to bear in mind, and I know that this approach, and Philip already outlined that this approach will not likely meet the WTO standards that are currently existing. So this is why I believe that the EU's approach and the approach of many other countries dealing with new types of market distortions, they highlight the need for amending the anti-dumping agreement. And for that, I think in order to make the EU's approach written into WTO law, at least two points could be raised in order to make that politically feasible. First of all, the EU's approach is one-sided in that it replaces only distorted cost in the production cost within the normal value. So it does not replace the same distortion within the export price. So at least if it's written into WTO rules that these market distortions should be captured and adjusted on both sides of prices, then the concerns of the exporting countries that are opposed to the EU's approach could be at least mitigated. And the second point is in that again, it should be ensured that if the same market distortion is captured by the countervailing duties and anti-dumping duties, then no double remedies should arise. It should be again be secured. But whereas the approach itself, the logic, anti-distortion logic behind the EU's approach is, to my opinion, quite reasonable. There are the other aspects of the EU's approach that deal with certain social or environmental dumping when they compare the prices from those countries having high social and environmental standards. So this aspect could be quite premature for other countries to accept, so as to write it into the WTO rules. And also, as Philip already said, this burden of proof issue when the European Commission itself issues the reports on significant distortion. So this part is also, I don't think that it will be accepted by other members because this could undermine the fairness of investigations. So except this, to my point, quite problematic areas of the EU's approach, generally the approach itself with respect to the logic makes sense, but in order to sustain that approach, it should be now maybe as a plan B for the EU could be to start the process of negotiating the anti-dumping rules under the WTO so as to accommodate that approach within the WTO regime. Thank you.
Well, that's sort of a good segue to another distortion that I want to bring up. The U.S. has proposed new regulations to address and to treat currency undervaluation as a countervailable subsidy. So I'd like to ask Tim to maybe give a brief description of the U.S. proposal and talk about the significance of the proposed change. And then Eugene, if you can talk about what obstacles you see to the U.S. proposal, both domestically and sort of as a matter of WTO law.
Sure, thanks, Stacy. And I also want to respond to the prior question too, just to say I also disagree with Philippe with regard to the ability to address a particular market situation. I think if you look at the biodiesel case, I mean, there are many in the room that know that case much better than I do, but Argentina challenged the EU's departure from its reported costs because of an export tax on soya, which is the raw material input. So that seems like a case that is tailor-made for departure from standard reported costs due to distortion in the marketplace. The appellate body found otherwise and found that if a respondent's costs are generally related to the production and sale of the product under consideration, then the authority investigating cannot apply an additional standard of reasonableness to reject those reported costs. And that's, again, in my personal view, that's a problem if we can't address obvious market distortions in these types of situations. So, and I'll go even farther, although it's a little dangerous. I know we have esteemed WTO people in the room here, but the United States has a few concerns with the appellate body these days. And I think this is, to put it mildly, and this is one of those examples of what you could consider overreaching by the appellate body. I don't think you have to amend the dumping agreement. There's plenty of authority there to address market distortions, and that's where we should be. It's not where we're at. Anyway, sorry for that side rant. The United States is, for the first time in after calls for decades, is trying to address the issue of currency undervaluation as a possible subsidy. So there have been proposed rules. There will be comments submitted at the end of this month, so it's a very timely issue. Our firm and many others will be commenting on those proposed rules. And in particular, this would clarify how the Commerce Department would determine the existence of a benefit resulting from a subsidy in the form of currency undervaluation. And it would also clarify, importantly, that companies or enterprises that primarily buy or sell goods internationally can be considered a group of enterprises for purposes of determining whether a subsidy is specific. And that's always been very important, because one of the challenges of treating currency undervaluation as a subsidy is whether or not it's specific or an export subsidy. So Commerce has now said if enterprises primarily buy or sell goods internationally, that could be considered specific for purposes of applying a subsidy, a countervailing duty. The other interesting thing is that the Commerce Department plans to defer to the Treasury Department regarding its evaluation and conclusion as to whether government action on the exchange rate has resulted in currency undervaluation. That has been a significant source of debate among Congress, Commerce, and Treasury. As you all know, Treasury has declined to name many countries, including China, as currency manipulators for years. On the other hand, importantly, Commerce has said that it reserves the right to deviate from Treasury's determination. So Commerce could disagree, if it has good reason to believe otherwise, with a finding of whether or not China or any other country is undervaluing its currency. So that's where the proposal stands. Again, it's just a proposed rule. There'll be a lot of interpretation to come, but it's a very important step on a critical issue.
Thank you, Tim. And yeah, this is a very timely issue. It's a very new, and I won't propose to know specifically what the proposals, what the proposed methodologies that are outlined in the proposals are, but I think just in terms of what obstacles there are, or what are the prospects for this proposal. I do think that politically that there would be a lot of support for this. As Tim mentioned, this has been in the works for many, many years. It's not something that's new. Those who have been practicing, that have been in the government the past years are very familiar with this effort. And in particular, these efforts were traditionally pushed by Democrats. So I think that there will be widespread bipartisan support for this revision or this modification to pass. I do think then we are starting to hear some importers being concerned about this, as is to be expected. But I do think that there would also be a lot of domestic support for this as well. So in terms of just internally, I think that there is a good chance of it going forward. One thing that is interesting is that I read recently that Treasury was somewhat surprised to see the proposed rule and its role in the rule, and that there was some concern within Treasury about market disruption and the politicalization of foreign exchange policy. So, this is somewhat of an interesting situation where it could be that the Commerce Department and the Treasury Department might not necessarily be 100% aligned in their position on this. And I think that we are seeing some of that in the U.S. administration these days, where agencies aren't necessarily seeing eye to eye or aren't necessarily communicating as well as we would want them to. So one thing to, I think, watch is just how the two agencies kind of approach this issue. In terms of implementation, again, there's a lot of explanation in the proposal that I won't purport to fully understand, but I think that the calculation of benefit will be difficult. There's undervaluation. My understanding is that there's undervaluation, and then there's unfair undervaluation, and then just kind of setting out what the benchmark would be if it is found that there is undervaluation. I think that will be something that's difficult both domestically as well as at the WTO. And Tim mentioned about deferring to the conclusions of the Treasury Department, but that Commerce can deviate from such conclusions if there's good reason to. Now, if Commerce does agree or defer heavily to the Treasury Department, then this might not have a lot of teeth. It might just be a tool that's out there that isn't actually used very much, much because there hasn't been findings of undervaluation. On the other hand, if Commerce does feel free to deviate from the conclusions and reach its own conclusions about that are different from Treasury's conclusions, I think that this could potentially open the doors for Commerce to exercise a lot of discretion in how these countervailing investigations take place. Finally, I think that just one thing to note is that this is a very important move. This is a very big move on the part of the U.S. government, but the impact, I'm not exactly sure how big the impact is going to be, particularly because currency undervaluation, if it exists, is obviously a countrywide issue, and it's a big issue. In the context of a CVD investigation or administrative review, it's going to address the issue in a fairly granular level. So, query whether this is really the best venue to be talking about this. But
Great, thank you for that, and then thanks for the panelists. And I know we started late, so I'm gonna take a little bit of liberty and do at least one round of questions from the audience. And do we have somebody with a microphone? Why don't I take some questions, and we'll take them. We'll take 4 questions, and then we'll put them to the panelists. So, and there's one starting in the back there. And again, please ask a question, and ask a single question. And I'm looking at you, James. So, okay, in the back there, yes.
Yeah, Henry Gao from Singapore. A very simple question. I couldn't understand the obsession with NME status and with the use of anti-dumping, because if you are supposed to address the distortions in the whole market, then the dumping would only be actually the symptoms, and they wouldn't be the root. The root of the problem would be the subsidies, the industrial policies. So why don't we all forget about the 15A and use instead of 15B? Because 15B, provide a similar methodology, the alternative benchmark methodology for subsidies. And the best news about 15B is that it has no expiration date. So there's no need to haggle over, whether it expires 15 years after. So even 100 years after China becomes a WTO member, it could still be used, at least theoretically. So I wonder if the panel can elaborate on that. Thanks.
Okay, and the next question was the one back there.
Thank you. My name is Daniel. I'm working in the OECD. I wanted to support that approach, and I want to know if maybe you believe that the reason why the EU and the US are taking these alternative approaches is more because there are certain shortcomings in the agreement on subsidies and countervailing measures, and like the transparency shortcomings, the fact that it's difficult to calculate the pass-through in value chains, and that is the reason why they are trying to solve the problems through the anti-dumping, but it wouldn't be better to actually negotiate a modification of the ASEM agreement?
Okay. All right, James. But I'm watching you.
I'd like to ask the panelists to compare what China is saying about it being a market economy just like any other member with what we heard in the previous panel about what the United States is saying about national security meaning economic security. Do you find those positions similarly reasonable? Are they both justiciable? Somebody said Section 15 is not a model of clarity. Does that mean it's not justiciable?
Thank you.
I haven't quite, Stacey, sorry. I don't, let me just ask the question. I don't know whether any of the panelists have kids. That's my second question. But here is the question. When you look at that, what's your conclusion? I put it to you that this situation simply reinforces how important it is that we can resolve these kinds of disputes using a dispute settlement system that's properly resourced, that we trust and that we believe in. And isn't this panel and the previous panel just the living proof that what we need and what we must treasure is mandatory and binding dispute settlement?
All right, one more question. Over here, yep. To the right. Sorry to make you run up and down the stairs.
Thank you. My name is Xu Xin from Shanghai, China. So my question is to Mr. Philip, and comments from other panelists will highly appreciate it. So we know that there's widely accepted concept on the WTO system that de facto discrimination and the legal discrimination. So if EU can prove that your new regulation does not constitute a legal discrimination, so how about de facto discrimination? Thank you.
All right. I open it, whoever grabs the mic first can go first, but there's a number of questions here that I know all of you want to address. So I'll start, why don't we start at the end there? Tim, you go first, and then people can comment as they see fit.
I can try on a couple of these. I apologize if I'm not answering the question fully, but the question about anti-dumping versus countervailing duty and shouldn't, why are we focused on non-market economy dumping methodology when subsidies and other distortions are the real problem? I agree with that. And I think the problem is, just from a practical perspective, is transparency, as the second questioner mentioned, that in a subsidy case that I'll file against China, I'll allege 20 to 30 different subsidies, and it's very difficult to obtain information on the extent and nature of those subsidies. And so, for whatever reason, bringing an anti-dumping case using the non-market economy methodology has a better impact in terms of addressing the distortive practices. So I think that's practically why that occurs. Would it be better to renegotiate the subsidy agreement? I suppose, but I don't see that happening anytime soon. I do think, as the point was made about state-owned enterprises and industrial subsidies, there are certainly good efforts going on that front. We've worked very hard with the United States to put in provisions on state-owned enterprises in the US-Mexico-Canada agreement, and there are similar efforts going on with the EU and Japan. And if those kind of things could be adopted more broadly, then there would be potentially less of a need for that sort of methodology. Why don't I let some other, I can come back to some others.
I think regarding the question on anti-dumping and CVD, my own feeling is that why should actually countries use anti-dumping? So if you look at the distortions, the distortions can appear in different manners. It could be price control, it could be a heavy state control, state regulations. The SCM agreement is not actually capable of absorbing all these kind of distortions. Because if you look at the traditional test under the SCM agreement, there has to be a financial contribution, a public body or a government, then it has to confer a benefit and specificity. All these requirements are actually there. But in the case of an anti-dumping, the real advantage is that you can actually disregard the domestic cost and price and then treat China as per agreement. So, that kind of an option is not actually available in the case of a subsidy agreement unless it undergoes a serious or substantial change in the future. So, I mean, from an importing country point of view, it makes a huge amount of sense to go for an anti-dumping duty. So, I think regarding the other questions, I will give it.
Thank you. I tend to disagree with the two previous speakers. I think anti-dumping and anti-subsidy address two different issues. You can, for instance, a typical case in the past was anti-dumping investigations against South Africa, where the dumping arose really out of the geographical isolation of South Africa. So if they exported, they had huge transport costs. If they wanted to be competitive, they had to reduce the prices. These were private decisions. Second, anti-dumping is possible as a result of market segmentation. Market segmentation is often a result of import duties. If you have high import duties, it makes it possible to export at a lower price than on your domestic market without being afraid that the exported product will revert back or return back to your market and compete with yourself. Are we going to say that import duties are state intervention which leads to a distortion of costs or is a subsidy? I know people say it about export duties, which in my view are purely the mirror image. So it should not be considered as a distortion or as a subsidy. It is, however, true that the subsidy agreement needs some refreshing if we want to use it effectively for cases that problems we now want to address under the guise of anti-dumping. And issues like that is obviously the notification of obligations for existing subsidy schemes, the problem of how do we interpret public body, issues of specificity. And then I think here specificity will be an important question if we have these currency manipulation cases, because they will not be specific. So therefore, I agree. We should not mix up anti-dumping and anti-subsidy, but I agree that anti-subsidy needs some work. As for the questions of James, I don't think, as many of James' questions, that this was a real question. I think it was clearly rhetorical in the sense that there's so much ambiguity possible in different interpretations that we indeed need someone who decides in the end which way we will go, and that the appellate body, with all its defects, is probably the best institution we can probably imagine in order to do so. As for the question on and if I would enter into rhetorical question, I would say that the difference between both is that market economy is a term which does not exist in WTO law, while national security does. So I think we should differentiate it there. De facto or de jure discrimination, I agree that the new EU methodology, you would have a strong case to allege that there is a de facto discrimination. Why is that? The whole legislative work leading up to it, where everybody said we have to do this because of the expiry of the parts of the protocol of accession. We have to have this country report ready. We should maintain the same level of duties as we had previously. The fact that until now, and I lost count, but I guess we had around 20 new investigations that were initiated after the new methodology came into force. It has only been used against China, and it has only been used against China even in cases against Russia, where they found the existence of significant distortions in the energy price. So I think you would probably have a good de facto case there.
I'll be very brief. I agree that strengthening the subsidization rules would go a long way in helping out on the AD side, but I also agree that those are very separate. And part of it really does have to do with, I think, just transferring over the remedial effects of for example, a CVD duty into the AD realm. I think, Shirzad, you mentioned something about that kind of the subsidization measures addressing kind of the source of the problem, and then the AD measures kind of address some of the effects of it. I apologize if I'm misstating your point, but I do think that it's really the practical differences, including just like timing differences. If you have an AD investigation and a CVD investigation at the same time, for example, even if at some point those subsidization or anti-subsidization measures could remedy the subsidization at some point, there's going to be a timing issue on that as well. So I think it's just the practical problems that do require kind of addressing issues on both sides.
Thank you. So regarding the anti-subsidy issues again, I do agree that the subsidy agreement is better suited to capture government interventions that promote domestic producers rather than the anti-dumping agreement. But and I do agree that the subsidy agreement needs some revision to capture all new types of significant distortions that are now written into the EU's regulation on anti-dumping. But there is one thing that I think it's really difficult to get consensus among WTO members about what types of governmental intervention should be additionally restricted under the subsidies agreement. I mean, government, it's really sensitive, and the governments would not tend to, capture all, to say that all of these distortions should be dealt with under the newly revised subsidies agreement. So given that in mind, why not allow the the newly revised anti-dumping agreement to deal with the certain, at least significant market distortions, because the anti-dumping agreement deals with the effect of the distortions rather than with the government interventions that governments would not like basically restrict significantly. And given that in mind, I think that revising anti-dumping agreement is more politically feasible than revising the subsidies agreement in capturing all types of significant distortions.
All right, we have exceeded our time, and I apologize for that. But thanks to all the panelists for your great discussion, and thanks to the audience for the questions. Thank you.